What happens if I marry someone with kids and then get divorced from that person? Do I get to see my stepchildren in the future? I cannot speak to what the law is or how it is applied in every jurisdiction, but I can answer this question on the topic as it applies to the jurisdiction where I practice divorce and family law, Utah. We all know that there are many step-parents who are often the only parental figure many children have ever known, such as situations where the step-parent married the child's parent when the child was an infant or very young, or in other situations where the child may be older but never knew their biological mother or father, so the stepmother or stepfather is the only kind of father or mother figure they have had in their lives. We know of minor children and of people who are now adults who become as close or even closer to their step-parents as they were with their biological parents. We know situations where a stepchild who is cut off from that loving and positive relationship with the step-parent has been nothing short of devastating to that stepchild. At the same time, we know of many examples, more than you might imagine, in which a step-parent involved in a divorce with his or her stepchildren's biological parent does not have a particularly good relationship with his or her stepchildren, but claims a desire to want visitation or parent time with his or her stepchildren, or even might seek custody of his or her stepchildren as a means of gaining leverage in the divorce action, or just plain being malicious toward the soon-to-be ex-spouse. And so there are many interests that need to be considered and balanced if and when a step-parent tries to seek visitation rights with or even custody of his or her stepchildren. Note, if a husband and wife, one or both of whom are step-parents, agree that a step-parent is important to the children and that the children should maintain a close relationship and frequent contact with the step-parent, there is nothing to prevent these divorcing spouses from agreeing to rights of parent time or even shared custody, as long as the biological or adoptive parent or parents of the children whose parental rights have not been terminated, or a guardian or guardian ad litem are not opposed to it. Here is how Utah currently handles such a situation. Effective September 1st, 2022, this is the law as it is in Utah. As you will see, there's a high bar set for a step-parent who seeks an award of visitation or custody of stepchildren. See Utah Code Title 30, Chapter 5A, entitled Custody and Visitation for Persons Other Than Parents Act. Let's start with Section 30-5A-103, which provides, among other things, that, quote, "It is the public policy of this state that a parent retain the fundamental right and duty to exercise primary control over the care, supervision, upbringing, and education of the parent's children," close quote. Section 30-5A-103 also provides, quote, "There is a rebuttable presumption that a parent's decisions are in the children's best interest," close quote. That presumption can be rebutted, and custodial or visitation rights can be granted to an individual other than a parent who, by clear and convincing evidence, establishes that A, the individual has intentionally assumed the role and obligations of a parent, B, the individual and the child have formed a substantial emotional bond and created a parent-child relationship or type relationship, C, the individual substantially contributed emotionally or financially to the child's well-being, D, the assumption of the parental role is not the result of a financially compensated surrogate care arrangement, E, the continuation of the relationship between the individual and the child is in the child's best interest, F, the loss or cessation of the relationship between the individual and the child would substantially harm the child, and G, the parent, sub 1, is absent, or 2, is found by a court to have abused or neglected the child. Finally, Section 30-5A-103 provides that with rare exception, a court may not grant custody of a child under that section to an individual who is not the parent of the child and who, before a custody order is issued, is convicted, pleads guilty, or pleads no contest to a felony or attempted felony involving conduct that constitutes any of the following: A, child abuse, B, child abuse homicide, C, child kidnapping, D, human trafficking of a child, E, sexual abuse of a minor, F, rape of a child, G, object rape of a child, H, sodomy on a child, I, sexual abuse of a child or aggravated sexual abuse of a child, J, sexual exploitation of a minor, K, aggravated sexual exploitation of a minor, or L, an offense in another state that, if committed in this state, would constitute one of the aforementioned offenses. Now, there are many more details in the code governing custody and visitation for persons other than parents, but what I've covered in this video is where you'll start if you or someone you know is a non-parent who wants to seek custody and visitation of stepchildren.